First, it's intended to generate additional finance to pay for RSK's expansion of the business into the UK, particularly by buying the machinery. That fast cash is to come in by charging an upfront license fee, followed by a royalty stream. Next, the license is intended to provide a low cost and rapid expansion into new markets that RSK could not otherwise enter. And finally, it's intended to be an interim step so that in due course, RSK can terminate the license and enter the market and sell direct to customers itself. And this is all fine for RSK, but it's not so attractive when you look at it from the licensee's perspective. The licensee is being asked to pay a lump sum upfront for the right to develop a new market entirely from its own resources and at its own risk and cost. And then at some time in the future, presumably when the market is suitably attractive, to lose its license and hand over the fruits of its labour to RSK. We should note that these are not unusual considerations. Every license will begin and end. Every commercial license will involve some form of payment by the licensee to the licensor. And every license will probably require some level of investment or costs to be borne by the licensee. But what makes our case today interesting in respect to these aspects is the interplay between them, which is starkly apparent at the outset.
So looking at the financial terms, I mean, from RSK's perspective, the simplest and best model in terms of royalties is if the royalty is a percentage of the licensee's revenue from the sale of the licensed products. And what do we mean by licensed products? Well, those are the products being produced using the licensed technology, or if there's a patent involved, those are products which are claimed by any of the claims of the patent, or if this is evolved to a point where there's a brand that's being licensed, they're products that are sold under that brand. Obviously, consideration is going to need to be given to what we mean by revenue. Is it gross revenue, which is obviously the best for the licensor? The licensee will clearly want to discuss deductions for example, for discounts, any product returns, and perhaps certain expenses. Alternatively, and this is probably less common, royalties could be based on the profit made by the licensee. And that obviously shifts the balance of commercial risk away from the licensee and makes it more of a shared risk. But it increases the complexity because one has to define what's meant by profit.
With respect to the license itself, it's a relatively easy thing because where litigation might be involved is if somebody breaches it, it just becomes a contract dispute. But there are a couple major litigation issues that could pop up that people usually don't think about. One has to do with exclusivity that you just mentioned, and the owner of the patent is the person who can bring a lawsuit, but at least in the United States, the exclusive licensee can as well. A licensee cannot, but an exclusive licensee can. And if that happens, the patent owner is joined in with the exclusive licensee. The problem is that the interest of the exclusive licensee and the patent owner may not be aligned in certain respects. First of all, litigation is very costly in terms of expense and time, and that may be something that the patent owner may be unhappy to spend, although the licensee may be interested. The second thing is the patent is put at risk in litigation because the court may find that the patent is invalid. And that would be very bad for the patent owner. And actually, the licensee might like that because if the patent is found to be invalid, then the licensee can stop paying royalties. So that is an area where it's different.